So why should we or our students care about the Fugitive Slave Clause? Unlike the Commerce Clause or the Second Amendment, the Fugitive Slave Clause is not a current source of constitutional controversy, nor the Fugitive Slave Supreme Court cases, Prigney, Pennsylvania, and Abelman v. Booth, as famous or infamous as Dred Scott. So why care about it? I'll give you three compelling reasons. First, the fugitive slave crisis in antebellum America was central to antebellum politics, much more so than historians have recognized. Second, the debate over the Fugitive Slave Clause's meaning and operation raises key questions in American federalism. Federalism is, arguably, the most important and vexing component of the American constitutional system. And third, resolution of fugitive slave issues at law left a lasting imprint on American federalism, one that continues to this day. In fact, the current controversy over federal immigration enforcement and state cooperation is rooted in concepts developed by fugitive slave jurisprudence. We begin with the text of the Constitution itself. The Fugitive Slave Clause was proposed late in the Constitutional Convention and did not arouse much controversy. The initial proposal was that fugitive slaves would be delivered up like criminals. Roger Sherman objected because the language implied that states would have to pay for hunting down and jailing fugitives. The language was changed, and the delegates unanimously approved the Fugitive Slave Clause. The clause was ultimately placed in Article 4, Section 2. It was not the most elegant clause of the Constitution. It was, in fact, filled with the kind of elisions and dodges that are present throughout the document, at least when slavery is concerned. Slaves are persons held to service or labor, and they are only held to labor under the laws of a state. And the entire clause is written, frustratingly, in the passive voice, meaning we are not certain who is to be enforcing these fugitive slave laws. Congress would pass a Fugitive Slave Act in 1793. The law gave slaveholders seeking fugitives a process to follow for reclaiming their fugitive slaves. The law empowered federal courts and state courts to issue certificates of removal. This piece of paper, the certificate, would then give slaveholders the power to take fugitives back to their home states. Almost immediately, there were problems. Northern congressmen began complaining about the kidnapping of free blacks, sometimes done under the cover of the Fugitive Slave Act itself. But Congress declined to pass an anti-kidnapping law, in part because they could not find a constitutional warrant for Congress to pass such a law. Congress, after all, was a government of enumerated powers, and any power not granted to Congress was reserved to the states or to the people. This was a concept implicit in constitutional doctrine during the 1787-1788 ratification debates, and made explicit by ratification of the 10th Amendment in 1791. Kidnapping was a crime against persons and was punishable by state laws. And indeed, there were already state laws on the books punishing kidnapping. Virtually every state made it a crime. But now, states recognized that the Fugitive Slave Act might be used as legal cover by kidnappers. In 1824, Pennsylvania passed a Fugitive Slave Act, although it came to be known as Pennsylvania's Personal Liberty Law. The law gave protections to anyone claimed as a fugitive slave, including the right to have counsel and to testify on their own behalf. It also imposed evidentiary standards on slaveholders, including the requirement that they bring at least 2 witnesses, neither of whom could be themselves, in order to prove the status of a fugitive slave. Eventually, this law was challenged and brought before the Supreme Court in the case of Prigney, Pennsylvania. Before the court, abolitionist lawyers argued that the protection of free blacks was an important police power of the state. No one disputed this. In fact, southern slaveholding states had passed laws protecting their own free blacks from kidnapping. But abolitionists also argued that the Fugitive Slave Act was unconstitutional. They made a persuasive case. They began with the premise that the United States was a government of delegated powers, and delegated powers only. Recall that this was the same logic that congressmen had used in the 1790s to reject anti-kidnapping legislation. Then the abolitionists argued that the Fugitive Slave Clause did not empower the federal government to pass a law. The clause, after all, had no language giving Congress the authority to pass a law. Congress's powers are found mostly in Article 1, Section 8, but they are spread throughout the Constitution. They are certainly found in Article 4, where the Fugitive Slave Clause is located, but there is a critical problem here. Sections 1, 3, and 4 of Article 4 all have enabling language. In Section 1, the Full Faith and Credit Clause, it explicitly states that Congress may by general laws prescribe. Article 3, the Admissions Clause, says that states may be admitted by Congress. The Territories Clause explicitly gives powers to Congress to govern the territories. And the Guarantee Clause says quite specifically, the United States shall guarantee and shall protect the states under the circumstances listed. Section 2 has no enabling clause at all. And a simple rule in statutory construction is that you assume the express mention of certain things necessarily excludes things you do not mention. To repeat, a simple rule in statutory construction is that you assume the express mention of certain things necessarily excludes things you do not mention. If Sections 1, 3, and 4 all have language enabling Congress to pass laws, and Section 2 does not, one must presume that it was left out on purpose. It follows that Congress has no constitutional warrant to pass fugitive slave laws. It was a clever argument, but it did not carry the day. Justice Joseph Story wrote for the opinion of the court. He declared the Fugitive Slave Act fully constitutional, and he declared the Pennsylvania Personal Liberty Law unconstitutional. Story's reasoning began with the premise that the American constitutional system was one where dual sovereigns operate. The federal government is sovereign in some cases, the states in others. Powers are divided up amongst them, and each is absolute in its sphere. But some powers are concurrent. Taxation is an obvious example of this. The regulation of commerce is another example, as the states are free to regulate it until it becomes interstate commerce, making the dividing line an important and difficult one to draw. Regarding fugitive slaves, you had two powers at issue. One was the return of fugitive slaves, the other was the protection of people from kidnapping. But the laws were regulating the same activity, fugitive slave reclamation, and this activity affected both problems. How would the court resolve this? Justice Joseph Story used two lines of reasoning to answer the problem, both of which depended upon the Supremacy Clause. The first is known as preemption. This reasoning holds that a state law may be perfectly constitutional and valid until a federal law governing the same subject is passed, at which point the state power is preempted and all such legislation is invalid. Story's second line of reasoning was to adopt the position of exclusivity. If the Constitution delegated a power to Congress, then that power cannot ever be exercised by a state. This is a powerful holding, one that would later be the theoretical engine used to power the dormant Commerce Clause doctrine. But Story's pro-slavery ruling had an anti-slavery silver lining. It was also provided by the idea of dual sovereignty. The federal government, under this doctrine, could not force the states to enforce federal laws. The Fugitive Slave Act of 1793, we will recall, had extended jurisdiction to state courts. Justice Story agreed that state officers could take jurisdiction under federal law, but they could not be compelled to. One by one, northern states passed laws that made it a state crime for their officers to enforce federal law. Congress responded by passing a new Fugitive Slave Act in 1850. This heinous law stripped alleged fugitives of what rights they had, appointed commissioners to hear cases, paid those commissioners more if they returned fugitives than if they did not, criminalized resistance to fugitive slave reclamation, and so on. The Supreme Court declared it was constitutional in 1859 in the case of Ableman v. Boone. So that's the short history of the fugitive slave cases and of the constitutional controversy that they engendered.